Actually, maybe I'll ask Lana if you could kick off.
Sure. And I'm really happy that you could arrange for me to do this by phone, because I'm very interested to hear everyone else's views and move the discussion ahead. I'm a lawyer in Toronto, Canada, and I've been working in disability law for almost 20 years. And I've worked, spent several years working at Arch Disability Law Center, and I've also worked in private practice. And I've been working in the area of capacity laws since way before the CRPD came into force. And the CRPD, and I know that I was writing on law reform in relation to capacity before the CRPD, and it was very interesting because while I wrote about supported decision making, no one was much interested. So the CRPD has been wonderful to sort of force everyone who wasn't interested to engage in the dialogue in view of Canada's ratification. But my paper is primarily focused on sort of what supported decision-making has looked like in Canada, because I was thinking that for many of you who don't work in Canada and aren't that familiar with our laws, I thought that you'd be interested in getting some ideas of what's happening, because Canada actually has taken several different approaches. The reason that we have so many laws that deal with capacity is that it's under provincial jurisdiction. So every province and territory in Canada has its own laws that deal with capacity. And what that means is that we have many, many examples to choose from and to talk about. And for a jurisdiction or a country who hasn't even started down the road, I think that Canada can provide a really nice backdrop of some different legislative approaches. That said, I think I'm going to start by telling you that I don't think, to me anyways, the wording of Article 12 is not specific enough to know what exactly Article 12 means in terms of supports and supported decision making. So as I've been sort of thinking this through and writing on it and studying laws, I sort of concluded that you could interpret Article 12 to allow for two or three different types of laws in the context of support. So I categorize that. One would be giving supporters and supports legal status vis-a-vis third parties. So what that would mean is that I would appoint someone to act as my supporter, and anyone who I interact with has a legal duty to recognize my supporter and include him or her or my support should they not be people but plain language or whatever else might be, that they have to actually recognize the supports and allow them to be part of the decision-making process. The other way that I think Article 12 recognizes supports is by Article 12.3 in particular talks about states' duties to provide access to people to supports for decision making, and that I think my impression is that aspect of Article 12, the concept of state duties to provide or arrange for the provision of supports, has been emphasized less than giving supports and supporters legal status. Or certainly when you look at Canadian laws, my interpretation is that the legal status component has been much more prominent than the state's duties component. And I think that that's an important thing to think about, because there are many people who do not have supporters in their lives. And I think that when I've canvassed people especially in the older adult community, and I haven't done extensive canvassing, and also people with the psychiatric consumer survivor community, one of the pushbacks that I get relating to the concept of supported decision making, well, there are two main pushbacks. One tends to be One tends to be that people don't have, especially older adults, that they don't have supports in their lives. So if Article 12 is interpreted only to give legal status supports, but not legal status to supports, but the state duty to provide supports is not emphasized and pushed, it means that supported decision-making only means something to someone who already has supports in place. So, and it's interesting, a woman named Michelle Browning from Australia did a bit of a trip to some jurisdictions in Canada and also to England, and one of the conclusions that she made was that supported decision-making in some parts of Canada has not been used very much, and that's attributed to the fact that many people don't have supports, and especially people who may live in a remote community, and Canada has many remote communities. So I think that it's really important not to overemphasize one aspect, but there may well be other legislative mechanisms for recognizing support through different forms of supports that I haven't thought about, and the jurisdictions in Canada haven't, so I'd be interested to hear what other people say about that. In terms of sort of looking at all of the jurisdictions in Canada, I sort of recognize three broad approaches. So one is the legal recognition of supporters and support. And that takes basically two forms. The one that I think most people internationally know of is what they call representation agreements in British Columbia. And that's what uses the tool of a planning document where someone chooses who they want to act as their supporters. That kind of a planning document is also in Alberta's legislation and in the Yukon's legislation. It is, in some of our provinces, it is a bit weak because, for example, in Alberta it only relates to personal decisions, not property decisions. So what happens if someone wants to access supports to open a bank account? Being able to appoint supporters doesn't help them. British Columbia, in the same way, is limited to personal decisions and routine financial decisions. So they're not always. But I think my recollection is that Yukon covers all types of decisions. So there is some limitation to that tool placed by the different pieces of legislation. The other way that supporters can get legal status is through a mechanism which we sometimes call co-decision making, and that is where the person doesn't appoint their own supporters, but a court will, instead of appointing a guardian, will appoint supporters. And this is often referred to as co-decision making, and is has been in effect in Saskatchewan for a while, recently came into effect in Alberta, and is also in Quebec, but uses the term advisorship instead of co-decision making. So that's sort of the first category. The second category is where there's some requirement on the government to provide supports to a person to enhance their ability to make decisions on their own, so that there's no sort of supported decision-making order issue. Manitoba is the only province that I found that that requires the facilitation of supports that's outside of adult protection. The legislation is quite unclear to me as to, supports aren't defined really, which makes it hard to know what kinds of supports they're really talking about. And so I think a lot of the supports that the government provides are disability-related supports and not decision-related supports. But having spoken to people in Manitoba, it appears to me that there is a mechanism in place, and having read also their legislation,